Welcome to today's webinar. I'm thrilled to be joined today by Donal Griffin, a noted international estate planner. And he's going to be talking with us about estate planning considerations for the American in Australia. Let's carry on here. So, of course, no presentation is complete without some disclosures here about the reliability of the information. And also, while today's presentation is very interesting and maybe pertains to many folks here in their situation, it is not a substitute for obtaining personal advice. There are some clients who I'm pleased to see are joining us here today, but if you are not a client, then do not take this as advice that is particular to your situation, and you should seek your own counsel here. Also, perhaps, Donal, if you wanted to mention anything about your own disclaimers, maybe not. People are able to read that. Up to you. Do you anything to mention?
Well, actually, in a nutshell, it says, like Homer Simpson, it wasn't me. I wasn't there. I didn't do it. Don't come after me. Lawyers go to court for free and for fun. So, yeah.
I should mention that this presentation, like all of our monthly presentations going back for the past 5 years, is up on our YouTube channel, including last month's webinar, which was very well attended. We had 180 folks register for that, retiring to Australia financial planning considerations for Americans. So be sure to check that out. A little bit about me. I was really born into this cross-border financial world by being a tri-citizen of, Donald, don't hold it against me, the UK. The UK, Australia, and the US. I was raised in Brisbane. At the ripe old age of 23, moved to the US, worked in corporate finance until I saw the light in 2009, and I became a financial advisor. I learnt what it was to be a registered investment advisor. This type of entity didn't exist in Australia at that time. There wasn't such a thing as a fiduciary standard of care, and that really drew me. I was like, that is the way to provide financial advice, to be on the same side of the table as the client, working in their best interest. So I've had my firm Arete Strategists in operation now. It'll be our 10th anniversary on August 6th of this year. So we'll save the champagne until then. I'm also a regular conference speaker around the US. In fact, just booked another one for the National Association of Personal Financial Advisors in Louisville, Kentucky in November of this year. And I was a co-founder of the Global Financial Planning Institute. So it's important to know traditional financial planning is different to international and cross-border. And I think we're going to hear more of that today in Donal's presentation. But Donal here, you see him, this is a photo taken with his mentor. This would be Mr. James Hughes, and of course we all have our copy of his wonderful book. This was taken just 2 months ago in Aspen, if I recall correctly, right, Donal?
That's right. Yeah, it was. I've met Jay probably 12 times on Zoom, but this was the first time meeting in the flesh, and I didn't realize how tall he was.
Yeah, big
this photo shows.
Yeah, a big strapping American guy right there. So, so I was drawn to Donal. I actually reached out to Donal. That's how we first met, because I was looking for someone who had a very specific profile, someone who had lived that international experience. And you can read Donal's. Speaking of books that we have next to us, you can read Donal's biography. So if you want to know every little detail about Donal's life and what life he's lived and the experiences he's had, you can read that book. But professionally speaking, Donal is someone who's worked in a variety of capacities as an estate planner. He's worked very closely with financial advisors, and he's really focused on that matters most, and that is delivering the values that someone really hopes to encapsulate in their life and pass that on to the next generation. One of the designations Donal has, which it really doesn't speak much about, is this TEP designation. That's a trust and estate planner offered through an organization called the Society of Trust and Estate Planners. It's a British organization, very global in nature, and that's a a really respected designation for international estate planners. Donal, is there anything else, just introducing you here, that that you feel that folks should know?
I call myself a recovering financial advisor, Ashley. But I no longer practice in that, but it helps me understand where the bigger picture and goals and wealth are. So I think that's relevant.
I think it is relevant too. Yeah, I know about that. I don't know if I'm in recovery yet. I'm still addicted to that. Just a brief outline here. The kinds of clients that Arete Wealth Strategist works with would include these profiles you see here: the Australian business owner living in the US, the high net worth family, really getting settled in and thinking about what the future looks like, what exit tax options look like, how to consolidate their global wealth. And then the Australian executive family and his family that have permanently relocated to the US, so seeking to tie up loose ends in Australia. Those are the kinds of clients that we work with. But enough of that. Let's move on, and we're going to hand over the mic and turn the spotlight on to our guest presenter today, Mr. Donal Griffin. Please take it away.
Thanks, Ashley. It's lovely to be here and to meet some of your audience and to share some ideas with them. Just to add a bit of color to the background to me, I'm a migrant, as you can tell from my accent, Irish originally. And I guess we have that in common with a lot of the people on the call. They have lived in more than one country. And that gives me a perspective, which is helpful before and after, and helps me kind of notice things that are better in one place rather than another. It also, interestingly, links in with a metaphor in this area of high net wealth. And that is where people are the first generation to create wealth. There's a psychologist in the US called Grubman, and he says that they are migrants to the land of wealth. So not only are we migrants geographically, but we may be the first generation who have had to grapple with these issues. And that has some kind of unique characteristics. It means that we tend to be the one who have to work out the answers to this. We were not born into this level of complexity. We've no role models, so we have to go and find people that we trust to understand these issues and grapple with them. And a big part of this is we grapple with them, but sometimes that means that other people in our family do not grapple with them. So we have to not only be the star player, but we have to be the coach in relation to this. So hopefully there's some people on this call who find out that actually the complexity is not going to cost them a lot of money in tax, but there is some complexity in intergenerational transfers of wealth, and it's the emotional side, if nothing else. So, and I do find that Americans do come to this a bit more quickly than Australians, because they realize that there is a tax issue that they really have to get their head around. I'm looking forward to talking you through these things. So I'm an Irishman practicing law in Australia. So it's important to know we do not practice and advise on US law, but like migrants, like you, Ashley, we tend to attract people a bit like ourselves, and people who've walked somewhat down similar roads. So we do have a lot of clients with who come from somewhere else and may have assets in different countries. And that's where STEP comes in very handy, because it's a community of tax and estate practitioners around the world. So we can tap in to experts who we are not financially aligned with, but have common interests with. So if somebody comes to me in Australia and says that they have a house in Australia, some superannuation, I know, because of the property market, that their assets are probably worth a couple of $1 million. They may have a big mortgage which funded that property, but with good financial advice, they may well have insurance to clear that mortgage. So I'm talking to people who generally have a couple of $1 million of assets. And if they have children, in particular, I say, how does it look if you divided your net wealth by the number of children you have? How does that look in the hands of this 18-year-old boy, for instance? So it might be they've 3 children and a property and super worth $3 million, $1 million each. I say, how is that going to look in the hands of that child? Are they going to remain motivated with their studies? Are they going to be attracted to a flash lifestyle that they haven't actually funded otherwise out of their own exertion? Are people going to sniff out that they're trustafarians or they have access to funds? And the answer is usually that is a bit of a worry. So trusts are the way that we manage that in Australia. It's a discretionary trust. It's different to a US trust. So in the US, as your audience will know, there's a very broad reach from the IRS, and they take a view that trusts are really grantor trusts. And what that means is whoever set up the trust controls the trust. So it does not achieve in the US what it achieves in Australia, which is to be able to say, well, I don't actually control these assets. I have a trust that owns my business here, and it's called It's Not Mine Pty Limited. So that's effective in Australia. It would not be effective in the US. As a result, if I'm talking to US clients or people with assets in the US, they may well, with advice, set up an irrevocable trust, which, as the dictionary definition suggests, means the money is in that trust for all time and they lose control. They cannot take that money back out of it. So if you're going to set up a trust which is going to be effective in the US, you should check whether it is irrevocable. Now, there are estate taxes in the US and gift taxes, which is important to remember that estate taxes get a lot of attention, gift taxes less so. But there is a reporting requirement for gifts, which people need to bear in mind. Now, once people put money, we're aware that some of their money would go, if it goes to their children, it would be subject to tax. The tax industry created a structure called a generation skipping trust, which meant, well, they could say to the IRS, the money's not going to my children, it's actually going to go 37 and a half years to be exact down the line to probably my grandchildren or other people. The US IRS caught on to this, and they introduced a generation skipping tax, which essentially means the same tax applies for those generations. So that strategy was defeated. But in Australia, we use discretionary trusts, and they have tax advantages because you can stream the income and capital to different beneficiaries in different years. So you can essentially take account of the different marginal tax rates and different earning income that kids may have when they start uni, when they're working, when they're maybe taking time out of the workforce. So all of which allows you very legally to distribute income to different people, and essentially the family pays lower tax overall. So that's why irrevocable trusts don't work in Australia, because we don't need them. We can use a discretionary trust that gives us all the tax advantages that we want. Now, there's discretionary trusts which you set up during your life, and then there are testamentary discretionary trusts which are in your will. So sounds like a lot of trusts. And here's another trust. Trust me that this is not rocket science. If I can get my head around it and make a successful business telling people about it, it really isn't that hard. And ultimately, people need to conceptualize it and understand that it's maybe just separate different pots. One pot here for my business while I'm alive. My kids will have to get control of that. And then I've got my superannuation, which is another pot with separate tax treatment, which people, initially struggle with, and then go, okay, I get it. It's my best friend. So diligent, paying attention, building a relationship with an advisor who can explain complex things to you in a simple way, which you and the next generation, your kids, can understand is really important. Okay, so might move on to inheritances then. So the good news is there is no inheritance tax in Australia. There is, however, in the US, it's 40% on amounts in excess of around $6 million if you are a US resident citizen domicile.
I should mention it's actually increased in 2023. It's now up to 12.96 million per individual with spousal portability.
You're right. God damn it, that's right. Thank you, Ashley. It was 5 and 6 million forever. Mm-hmm. It is a political football in the US. There was a number of years ago, when it reduced to 0, and that the strategy was that was a good year in which to die. You're quite right. It has moved up to 12 million. Thank you for correcting me on that. Actually, do you want to talk about, so while I say there's no obvious Australian taxes, do you want to talk to the no stepping basis?
Well, thank you for that, Donald. That's something that's come up that I've really realized in speaking with CPAs over the years, is that while Australia may get credit for not having certain taxes, in fact, they really do tax similar events. They just tax it differently. And when journalists are, in the Sydney Morning Herald or the Financial Review or the Australian, they write about Australia having no estate tax, technically that is true, but the big difference comes in the lack of step up in basis. And so on the US side, you die, you've got this wonderful, financially at least, a wonderful thing that happens, and that is an asset that might excluding certain retirement accounts, assets that might otherwise be taxable had they been given away or sold during that person's lifetime, they get stepped up in basis to the fair market value at the date of death. Australia doesn't do that. Australia says, we're not stepping that asset up. So that stock that you bought back in the early 1990s that's quintupled since that time, your basis is still the original basis. And whoever you happen to bequeath that stock to, they're going to be paying capital gains on that original basis. So that's one example. The other example, which doesn't really pertain to today's presentation, but would be with the exit tax. And that is, Australia doesn't have an exit tax, but it kind of does. They just refer to it as taxable Australian property. And you'll be on the hook for it if you leave Australia. If you come back, it'll really be a problem. If you don't come back, then it might be someone else's problem. But point is, they are taxing the same kind of events, just doing it differently. So thank you, Donald.
Thank you, Ashley. Well explained. And look, there's a couple of perfectly legal loopholes in Australia which are important to know. It comes down, one of them is around capital gains tax, which touches on what you just spoke about. And there is a loophole which says that if you transfer assets to a person and they hold on to them and do not sell them, there will not be tax if they were post 1985 purchases and acquisitions. If they were pre-1985 acquisitions, the person gets the cost base on the date of transfer to them, which means it's the current market value, so that if you sold those assets the next day, there would not be no tax in Australia on them. But it is important to know that normally when you transfer assets, even to family members, the Australian tax office take a view that you have transferred it to a new person who might be a stranger, and deemed value is attributed to that transfer, and there is some tax payable. The loophole is in an inheritance and to a testamentary trust, there is not, that they do not trigger that tax.
So in other words, I just want to make sure I get that correctly, and also our audience understands that there's no tax due at the time of transfer, but should that beneficiary then sell that asset, then their basis is the original basis of the asset, except in the case of pre-1985 assets where there is a step up in basis because that before 1985, there was no capital gains tax. So the ATO doesn't want to miss out on their bite of the cherry. And did I capture that correctly?
Absolutely, that's right.
Okay. And then one other question there for you, Donal. What about transfers between? This is not really to do with death-related estate planning, but transfers between spouses. In the US, there's a unlimited marital transfer. What's the situation in Australia?
Well, in Australia, it is on a state-by-state basis. So you're because land tax and stamp duty is on a state-by-state basis. So in New South Wales, a person can transfer half of their main residence to their spouse for no stamp duty, no capital gains tax, and there is no gift tax in Australia. So that can be achieved. And that's often a very good strategy for people who are in business and may have a legacy property that they bought before they met their spouse, and they realize that they're the only director or business owner who owns assets in the business. So it's actually a good idea to reduce your assets. We do quite a lot of work, and sometimes using trusts for people to reduce their net assets to make themselves look like a smaller target. So that expression, which I presume you learned as a young person, I think it's international, that you cannot get blood out of a stone. And property is 9/10 of the law. So the bottom line, if you come to a lawyer and you say, I'm disappointed with what somebody has done, if the lawyer should properly bring the conversation around to, well, what assets does that person have? Because it may be a Pyrrhic victory if you got a judgment against somebody who has no assets. So that's what everybody's doing. They're moving their assets quite legally to other people within the family group.
Does that transfer, I think I heard you say that's only for the main residence. Could you do that with an investment property, perhaps?
You can, but the capital gains tax exemption would not apply. So it would be a transfer of your interest in an asset to a different person, and the government, the tax office, would collect some capital gains tax on that.
And stamp duty at the state level?
Yeah.
Okay.
So one of the strategies we have is actually to move the equity in a property into a trust rather than the legal title. So the title of these properties stay in the original person's name, but essentially we create a gift and a loan which balance each other out, so that there is no triggering of stamp duties. And I see a question there from Scott, which is quite correct. And of course, we can't cover every scenario, but there are rollover reliefs available in a bona fide marital property settlement as a result of a breakdown in a relationship. So very important for people to be aware of those rollovers. It has to be a genuine divorce. Back in the early 2000s, there was a situation in Australia where there was a breakdown of a business called OneTel, and Jodie Rich was the wife of one of the promoters of it. And allegedly, there was a divorce between her and her husband, and he gave her all his assets. But the courts found that that was not a bona fide separation. So I'm sure not only did they pay taxes on those transfers, but the money ended up in the hands of the assets ended up in the hands of creditors. I'm just mindful, I skipped over, you had the little video we have is just set up in the corner of the screen, and it obscures a discussion of other structures. So, and for people with a lot of money, there are things called dynasty trusts, and they are ways to avoid the applicable exclusion amounts and generation skipping tax. So Joe Kennedy Sr. famously set up his wealth in trusts which roll from generation to generation and apparently are avoiding tax. So that's a separate conversation where people would need even more tailored advice. But what we do, I've got some US clients who do want to make themselves small from an asset protection point of view, but they don't want to miss out on the marital exemption that you mentioned, Ashley, about transferring assets from a spouse to another. So we have crafted trusts which allow for that person to control assets on the death of a spouse in a way that does not mean that they have to they miss out on the double marital exemption, which is 24 million. And also in a way that means that the assets are exposed to creditors. So we've already done a little bit of work on this. So people are not necessarily starting from a blank page. But it is worthwhile saying that maybe I didn't stress the point, but we've got relations with lawyers in other areas where for instance, with superannuation, which I think is our next topic, we've educated them about how that works in Australia, and so that they're not going to, charge a fortune trying to work out, well, what is this whole thing called superannuation? So we can make a shortcut to that. With superannuation, what people don't realize a lot of the time is that if their super goes to children who are over 18, there is another tax point in Australia. And that is on the taxable component of their super. So when you get your annual statement from your super fund provider or your accountant, if it's a self-managed super fund, there is a section called member statements. And within that, it sets out the breakdown of the balance. And some of it will be taxable and some of it will be maybe tax-free. So what I'm saying is that 17% tax applies to the taxable component if it's going to go to children who are over 18. So people are a bit surprised by that. They feel, well, I've been getting advice, super is tax-free, isn't it, when I'm over 60 and I'm drawing an income. So this is a sneaky little exit tax that John Howard brought in when he announced the improved taxation on super in around 2007. So maybe, Ashley, are many of your audience, would you say, living in Australia and may in possession of superannuation funds?
Oh, absolutely. Yeah, nearly everyone.
Yeah. So this applies to everybody. So
yeah,
I think a takeaway for people would be to dig out that statement, and that will really bring it home. Look at the taxable component on their member statement and multiply by 17%, and that's a real tax that is likely to apply, and there, unless they take steps to manage it. And we have some strategies around that, which involve talking to the kids, so that they know. I tell the children of these people and your audience to contact you or me if mom and dad are in an accident, because when the second of them passes away, it is too late to move these assets around. And in fact, probably worth saying, in the context of estates, what people sometimes don't pay attention to is that when somebody dies, everything is frozen for quite a while. It may be 3 months, 6 months, 12 months. And what I mean by that is the banks, once they find out that somebody's died, will not transfer money or honor transactions on an account until they get what's called a grant of representation. And I think we mentioned this actually in our last discussion, that that applies in America as well. And every state there, as my US lawyers explained to me, say every state's a different country with different rules and different idiosyncrasies. And ironically, for, you know, arguably one of the more progressive states, New York State is, I'm told by my US colleagues, the last place where you want to leave assets, because getting a grant of probate in that state is a nightmare. So, and the states have their own taxes as well, which is beyond the remit of this discussion today.
It's worth mentioning, Donald, just to add a point to that, and that is life insurance. So, you know, Aussies typically love the idea of having their life insurance through their superannuation, and I can see why. You know, the premiums are paid with tax deductible, what were largely, if not entirely, tax deductible amounts. But the thing is that if the beneficiary is the super fund itself, and then the successor beneficiaries are non-tax dependents, then you just made your life insurance 15% taxable, versus on the US side, not only is it cheaper to begin with just for the cost of the insurance, but there's no estate tax that would apply on the US side, nor on the Australian side. So to me, that actually just adds to the case for, if you have the flexibility, if your situation calls for it, that you need life insurance in the first place, then, and you have the flexibility to obtain it in the US, then practically every time I say, get it in the US instead.
Yeah, good point. And we've got a self-assessment tool on our website, legacylaw.com.au, which prompts people to perhaps review their overall situation, and if there's a trigger point, to perhaps take some advice. And one such scenario is where the children move from being under 18 to over 18. And in Australia, that's a trigger point for saying to your advisor, well, should the life insurance that I have in super, should that now be outside of super, because my beneficiaries are now all over 18? And good advisors can assist with that. It may be that policies are cancelled and restarted without significant need for underwriting. But again, financial advice should be taken on that. But going back to inheritances in Australia, a trust is our preferred structure for people with a reasonable amount of assets. Now, reasonable amount could be a very low figure if your children are very young, or have a gambling problem or a substance abuse problem, because you may say they're going to get $300,000 each. Well, that's a lot of money to give to somebody who's got a gambling problem or a drug addiction. It could kill them. So sometimes, and maybe if you just flash that slide, actually, it's a little bit blurry on my screen, but this is an attempt to categorize what people should do and when. So if something is urgent and important, this is from Stephen Covey, his 7 Habits, which some of your audience may be familiar with. And it's really common sense. And a lot of what we do is common sense. And I like what you're doing there. That's that looks better on my screen. Thank you. So if it's urgent and important, definitely you've got to take action. If it's not urgent but important, well, then you need to plan. And I'm thinking that a lot of your audience will be in that situation, because hopefully they are well, and a death is something that is something that's further down the track. So it's not urgent, but it is still important, because they take advice. It's up to them what their philosophy is about paying tax, but presumably they love their family. If it's not important but urgent, well, then delegate it. And there are certain things. If they don't feel it's important, they can find people to help with estate planning and give them advisors. And then if it's not urgent or not important, well then, hey, look, we've all got enough nonsense in our life, and eliminate it. But the important, people say, when does it become urgent, or when does it become important? And I say, think about the sacraments of births, deaths, marriages, and the Australian sacrament of property ownership. And also when the kids go from being under 18 to over 18. Unfortunately, I don't know your experience, Ashley, but not that many children seem to become fully mature, independent, and responsible on their 18th birthday. In fact, they probably go a little bit backwards. And I think you've spent some time with me in my youth in that little book I wrote, yeah, so I know what I'm talking about, and I was the same. They say the frontal lobe of the male only forms fully when they're around 25. That's still pretty young, in my experience. And what I do find is, yes, great, the kids may get to 25 and be able to ask somebody like you sensible questions and keep asking until they understand concepts. But then guess what? They then fall in love, and which is a form of madness. And then guess what? This is all highly predictable. There may be children involved. And then guess what? There may be divorces involved. So these structures, while they're designed to protect younger people and people who may have very personal challenges, life is complex. So it does throw curveballs. It may be that the challenge is that they become a business owner. So what we find is that once we educate people around the use of these trusts in a family context, for tax and for asset protection, they often go, well, I want one of these trusts now. This sounds like a good idea. And they can use it creatively to protect the assets and manage tax very effectively. So maybe we could go to the next slide. Yeah. So look, how can discretionary trusts be used effectively? I mean, I say to children of your audience, if you come into an inheritance of, say, $1 million, if it's in I say to them, do you want $1 million cash, or do you want $1 million in a trust, which has tax advantages and asset protection features? Unfortunately, my poll, and I'd be interested maybe if your audience wants to comment, cash $1 million or $1 million in a trust with some features. I'm finding that overwhelmingly children will say, I'll just have them cash, thank you very much. So your audience are taking time out of a Wednesday to listen to us talk about this. So they've made the commitment to educate themselves, but the next generation don't necessarily take that on board. And we see people trying to dismantle these trusts. So my net point is that if you're going to have these trusts, it's a good idea to perhaps try and sell them to your children or to the beneficiaries so that they understand why it's being done and can see the values. And then you will either get peace of mind knowing that the kids get it, or you will be on notice that the kids are going to try and wind this structure up as soon as possible. So maybe we need to structure it in a slightly different way.
And when you say sell,
sorry.
You mean persuasively communicate, not literally sell.
That is what I should have said. Yeah. Explain. I mean, the metaphor in this area is, and this is from talking to Jay Hughes in Aspen recently with a whole lot of Australians and Americans who went to sit with him and hear what he had to say, is that if you prepare these documents, which can be very dry and dense, you have written a play, and that's great. Congratulations, you've written a play. But do the actors in the play know what roles they're expected to play? Have they given agreement to be on stage in front of their peers and others and carrying out some drama, which could be a farce or a comedy, with lines they're not familiar with? And the answer is, maybe some practice and a dress rehearsal is a good idea if this is not going to become a problem, because otherwise, one of the key actors may well say, I'm not going onto the stage. I've got stage fright. I'm not comfortable using these words. These are not words that I would use. I'm out of here. Give me my 1/4 share, please. And if you don't, I'll be talking to lawyers who have assured me that I will get my money. And then we've got litigation and, you know, families who may not talk to each other. So just having the documents on its own is a very old-fashioned way to do estate work, because it's not acknowledging that the family will have to live in the plan, or they will tear it up and go through lawyers to get what they consider to be theirs. Now, discretionary is an important word and worth a few minutes, because in Australia, discretionary trusts are so common that we find that the children think of them as unit trusts or as fixed trusts. So mum and dad see an advisor, they get advised to maybe set up a trust which helps them stream different amounts to different people on different years for different tax results. When that trust passes to the next generation, they're not interested in different amounts of streaming. They want, in fact, it's the opposite. They want exactly the same amount of income and capital as their brother and sister. So these, it's well worth people's while having conversations with the children to say, well, this in theory is a discretionary trust. It is not a unit trust. You do not have a fixed share of this. So given that, how are you 2, 3, or 4 or more children going to manage sharing what's a relatively complex asset? And if you don't have those conversations, it's just too easy to say, well, let's blow it up. And then all of the taxes that we discussed earlier on will be crystallized. The assets may be sold at times that is not opportune, but the children won't care, because whether they get $1 million and have to pay $1 million tax, it's still the biggest lump sum that they may get and considered worthwhile from their point of view. Might ask Ashley, for your experience, does that sound consistent with what you're seeing with your audience and their families?
That's very, very measured advice. And I think that sometimes metaphors can be very powerful and really get people to understand things in new ways. And I like the one that you used there about the play. You know, someone has written, but there's one I'd like to add to that. And it's a friend of mine who happens to be a business attorney. He has a metaphor for describing what trusts are. And he says, a trust is essentially like a FedEx box, like a box. It's a box with a recipient, a sender, and there's contents in the box. There's instructions for how to use the contents in the box. And in this case, building on your analogy, Donal, with the lines to a play, I guess what's in the box is a script. And, you know, do the folks that the estate pertains to, do they know that there's a play? Do they know their role? Do they know their lines? They know it's expected to happen, and what's going to unfold when mum and dad eventually pass on. But we had a good question here from Jason Shepherd. He writes in and he says, is it better for a dual Australian-American citizen living in Australia to set up a trust in the US or Australia? Doesn't the IRS treat an Australian discretionary trust as a foreign grantor trust and apply numerous taxes and potential penalties for it being offshore?
Well, that's a very good question. I don't think we'll get to the bottom of it because we're not giving specific advice in this call. But in terms of inheritances, it would be usual and common for a person to set up an irrevocable trust in relation to their US cited assets. Then the question would be, if somebody's a dual citizen, is their wife or husband or partner a dual citizen? And usually the philosophy is to keep the assets away from the US citizens if possible. So there could be a combination of a structure which might only be in a will, so that you can set up a trust in Australia during your life or in your will. So yeah, that's more questions for your audience member to consider. So they need to break it down. How do you eat an elephant? Bite by bite. So yeah, it is a complex question, but it's answerable. Just needs some numbers and to have a chat with a US lawyer. What we're doing with people is presenting scenarios just like that and getting our US lawyers onto a conference call where they give either verbal advice very quickly, because there is a treaty between Australia and the US, and some relief is available in different scenarios. There is no estate taxes in Australia, so you do not credit for US estate taxes is of no use to you in Australia, but some of the treaty can be helpful.
Mhm.
Okay. Do you mind going to the next slide, Ashley?
Sure.
I think we've covered that. So this is just an example of a generation skipping trust, where the exemption limit goes in, and then, but there is tax now. So we're finding that that's not as helpful for people. Sounds good, generation skipping. And if I'm talking to clients, you know, they often say, well, I want to look after my grandchildren. And we have to have a conversation about how that would work. And it requires a bit of sensitivity, because as a parent, you don't necessarily want your children assets to skip you and then go to your children, so that at 18 or 21, they have access to a couple of $1 million. When you're saying to them, no, you can't borrow my car because you crashed it the last time, or you didn't come back on time. Well, they say, well, hang on, it looks like my grandparents have set up a trust for me. I'm just going to buy a Ferrari. So while the grandparents might like this idea, and they generally do adore their grandchildren, sometimes it's with a bias and a blindness that the parent who has to manage them on a daily basis does not share or agree with. So maybe the next slide, please. How much time do you want for questions at the end, by the way?
We really have 12 minutes to wrap things up.
Okay, good. All right. Well, look, I like to put this slide in, which is just to reinforce how good it is to be an Australian. And that is that the tax regime here is generally quite favorable. So we are helping a number of people get their filing up to date so that they can actually exit as US citizens if that's what they want to do. So, and look, Shane Warne is another interesting character as well, because he is somebody who, moving on to a higher level, which may not be appropriate for this chat in detail, but broadly, as your audience will know, he was a little bit of a scoundrel and a playboy who rehabilitated his reputation, because he realized that if somebody wrote a eulogy for him, it would be detailing exploits, extracurricular exploits with drinking and gambling and match fixing and models, all of which are joyful in the mind of a sports player or a young person, but he realized he needed to rehabilitate his image, so he actually did. By the time he passed away very suddenly and untimely in his early 50s. So if Warney can do it, any of us who need to rehabilitate ourselves can, but you just need to start somewhere. Might move to the next slide, please. So here you go. So the 12 million threshold does apply to people who are US citizens. but it's 60,000, which is miserable if the person is not a resident or domiciled over there. So there are traps for people in relation to this. So the lesson may be that if they're not going to be domiciled in the US, that a US citizen is better placed to own assets rather than them. So I've seen some strategies where people buy property in the US through a company whose shares are owned by Americans, so that the shares are actually US assets and they're owned by US citizens. So the $12 million per person threshold is available. Domicile is an interesting one. It's a very old concept. I'll just read out from a US book we've got here. Domicile is a place where a person has his domicile. They acquire a domicile in a place by living there, even for a brief time, with no definite present intention of later removing therefrom. Residence without the requisite intention to remain indefinitely will not suffice to constitute domicile, nor will intention to change domicile affect such a change unless accompanied by actual removal. The issue of domicile must be determined based upon the facts and circumstances. It is not, however, to be confused with the concept of residence. So, what unfortunately may seem absolutely sensible and obvious to a layperson may not translate into the tax law and the results that people might think. So it is important. You can formally sever a domicile, you can document a domicile, and a lot easier for your audience members who may be moving from place to place and are familiar with their assets to do than for their children, because it's like doing a tax return for yourself, which I'm in the middle of in the throes of at the moment. I've got a good advisor, so it's not too painful, but for me to do the tax return for somebody else is very just beyond comprehension. And that's essentially a legacy for people who have the complexity of living in two different countries, having assets in different countries. So please make it easy for those who are coming behind, is my advice.
So I just wanted to add or tie together something you mentioned earlier, and that's to do with the US-Australian Estate Tax Treaty. And with that treaty, it's my understanding that Australians also get that, by virtue of that treaty, they get that what's now 12.96 million exemption, as opposed to if there was no estate tax treaty, it would be that $60,000 amount that you have mentioned there. So just wanted to tie those pieces together.
Yeah, that's right. And look, they may not get the full amount of the threshold. They may get a proportion of it, which reflects their US assets versus their non-US assets.
Okay. Yeah.
So these treaties are almost unreadable. So I again will be saying that you should be asking your advisor to clarify and to confirm their interpretation of it. Filing requirements. The tax in the US is often lower, apart from US estate and gift tax, than the tax in Australia. So what your audience may well find is that while they have a connection and a reporting requirement in the US, they're going through all the trouble of filling in the forms, but not actually giving the IRS any more money. So while that's good, we don't generally like paying tax. It's a lot of work to establish that you didn't need to pay any tax. So when I grew up in Ireland, getting a green card was considered a great get out of jail plan. And it was a ticket to a license to make money, apparently. And now we're finding, particularly with tech employees, that they don't actually need a green card and that these companies will often sponsor them. So
yeah,
be mindful that you may not be a citizen, you may not think you're domiciled, but if you own assets there or you had a green card, you may fall into the US taxation net. Okay, I think we've covered the less obvious taxes. You have super. We've covered. Look, issues for young children. Bottom line, if you're a parent, we've got we're parents till we die, right? But while the kids are under 18, it is very important for the parents to nominate a legal guardian. Where your audience, like me and you, have homes in different countries and different family members, it can be difficult, and it may be that they need a dual plan, which is one set of guardians in Australia and another in their home country in the US, where the kids may be more comfortable in one country than another. Without a trust, the kids will have, under Australian law, will get full access to their assets at age 18, which is normally a nightmare. The tax loophole in Australia is that with a trust, the children can earn $20,000 per annum and not pay any tax. And that $20,000, if it's not in the hands of the child and it's in the hands of an adult, it's just like a bonus, where you get the letter from your employer saying, congratulations, you've got a bonus of $20,000, but those mean people in accounts have kept 10,000 of it for tax. So it's quite an irritating letter when you get it. We've covered, look, the trustafarians, the wrong friends, we've covered that. Next slide, please.
I haven't heard of that one. That's a new one, trustafarian. In the Bay Area, there was the concept of the trust fund baby, which is what that sounds like. It's
pretty much the same thing, yeah.
Yeah, yeah. Okay.
But there's more marijuana, perhaps, with the trustafarian. Okay, substitution decision making, even if you can't get your head around or it's too complex for the whole estate business, it's really important that while we're alive, we nominate people to make decisions for us about financial health. Because otherwise, you may find that lawyers, auctioneers, bankers will not talk to you just because you've been married for a long time to somebody else. They won't talk to you about their financial or legal affairs. They won't allow you to sell assets. And that may require going to court to, which is a bleeding obvious. You were in the middle of an auction, but then your spouse or you became ill. That can stop the transaction happening. For health decision, what care we want, even assisted dying in certain states, all of that should be documented and made very clear for people so they can fight for you to get the treatment and care that you want. Next slide, please. It's a big topic. Okay, well, look, this is another topic again. If you want, bottom line is, nobody is prepared to transfer all of their assets. Their heirs are generally not prepared. So it is a process. It's a good idea to build some muscle and have some purpose and what's the plan here as a family. And for families with large wealth, this is what they need to do. This is the work outside of writing the play. It's developing the skills of the actors and making sure that everybody's got the opportunity to live the life that they want, rather than living a dream that a parent has dreamed up. And inheritors and creators of wealth are fundamentally different. And the creator has made it impossible for the inheritor to have the same desire to start from scratch that they may have had. So it's important to have some open, an understanding, but also some open discussions. I think we're out of time.
Yeah, we're pretty much at the top of the hour here. So I should, well, firstly, before we move on to your contact information, I did just want to mention next month's webinar. So I hope you can join us on Wednesday, June 21st, where I'll be reviewing. I may have a guest to join me. We're going to find out a little more about that later today. Personal financial planning moves for the Australian business owner expanding into the US. I've seen some really terrible things that have happened for very, very successful, smart, driven business owners on the financial planning side, because they just didn't know. Donald is one you might appreciate. What was good financial advice in Australia, namely starting your business, putting it in Australian trust, in Australian family trust, and then moving to the US and domesticating that as a Delaware C Corp, but then finding, because the beneficial owner of the shares are Australian Family Trust, you don't get US capital gains. It's all sourced back to Australia. Oh, but it's worse than that. It's at non-resident rates because you're not even living there. So we don't want that. If you're hoping to get a hold of me, please come to the Arete Wealth Strategists Australia's site, click on Get Started, follow that. We have other information available on the website also under the Knowledge Center. But if you're hoping to get a hold of Donal, this is how to do so. Please go to his website. It's legacylaw.com.au. Is that right, Donal?
That's correct. Yeah.
And there's Donal's email address right there. I'll give it another minute or two. But were there any other questions folks had that they were hoping we might be able to address today? I've found, Donal, that if you make that invitation, and suddenly people are jolted into writing those questions, and lo and behold, here's one. Nancy, what's not such a question as a statement? Thank you, Nancy. Currently in Australia visiting your new granddaughter. There's a story right there. Hey, granddaughter, a new granddaughter. Good for you. I hope your daughter has a little more time these days from the demands of being a partner. Partner at a law firm, not partner in a relationship. Chat, what else here? Laura, thank you, Laura. It's been really great, even for just stimulation. Absolutely. Thank you, everyone. And thank you most of all to Donal Griffin. Please feel free to contact Donal if you wanted to talk over your situation or inquire about his services. Thank you so much, everyone, and have a wonderful rest of your day. I hope you can join us next month.
Thanks, Ashley. Thanks, everyone.
Thank you. Bye-bye.